Attend this prestigious event and to witness at first hand just how well organised and of what high calibre it actually is. I'm confronted and surrounded by real experts in this complex field of EU procurement law, and I'm learning by the moment, let me assure you. I'm going to share some reflections with you today, not so much on issues of substantive EU procurement law, as more practical, prosaic, earthy questions of what happens when the wheels come off and it all goes horribly wrong and the parties finish up in a litigation scenario. I'd like to convey one very central message today, if I may, and that is that the court's approach to cases of this kind is nothing if not intensely pragmatic, at least in the jurisdiction in which I am dispensing something they call justice. The management of public procurement cases is a complex and demanding and challenging task for any national legal system. And I should add, by the way, before I move on, that the brief address which I'm going to give you is covered quite fully in a paper which will be accessible in the usual way following the event. I start with one general proposition, and that is that in the realm of the award of contracts governed by EU law, the governing rules, principles, standards and requirements on the one hand can be distinguished from the contract award methodologies and procedures of the relevant authorities in member states on the other. So far, so good. We haven't yet hit the question of remedies or litigation. Approached in this way, the main directive, and I'll refer to the main directive in that way throughout my presentation, it doesn't purport to prescribe an exhaustive model of contract award methodology. Rather, it has three main focal points. These are, firstly, governing rules and principles. Secondly, certain procedural or process requirements. And thirdly, the outcome of the competition itself. The 2004 directives are not comprehensive measures of harmonisation of the laws of member states. Rather, they describe themselves as measures of community coordination of national procedures for the award of the contracts which are affected. These, it is said, should comply as far as possible with current procedures and practices in each of the member states. Accordingly, those are preserved, but subject, of course, to the supreme medium of European Union law. Article 28 of the directive speaks directly to this issue. It says the following: in awarding their public contracts, contracting authorities shall apply the national procedures adjusted for the purposes of this directive. So wholesale harmonisation is not the aim or effect of the two directives. From that point, I attempt to formulate another basic proposition, and that is that the contract award practices and procedures of any public authority within the member states, with their own national idiosyncrasies, divergences and so on, will be lawful provided that they comply fully and faithfully with the principles and rules enshrined in the directives and imposed by general European Union law, another layer, and are compliant with such further rules as are contained in domestic law. One particular question which arose in one of our cases in Northern Ireland, a case called Easy Coach, which was a challenge to the outcome of a process procuring a contract for the award of certain public transport services, materialised when the contracting authority made clear from an early stage of the ensuing litigation that a final contract award decision had not been made. On further probing by the court, it emerged that the contracting authority was, come what may, proposing to engage in one final process with the successful bidder. This was labelled due diligence, whatever that might mean, but it may convey something to members of the audience. This gave rise to a practical case management issue for which there was no precedent decision. The court decided that the litigation should be suspended until this final process had been undertaken and completed between the contracting authority and the successful bidder. Accordingly, exercising, as the court frequently does in these cases, its inherent powers of procedure, case management and so forth, an order was made staying, that is, deferring, suspending the litigation for a finite period, 1 month in this case. That was to enable the process in question to be carried out. The court didn't order that to occur, although probably made fairly clear its view that it ought to occur, and in the event that it did. A second factor in that ruling by the court was that at that stage of the litigation it was very clear indeed that the contracting authority could not have considered certain types of evidence, and in old-fashioned public law terms had taken a less than fully informed decision, leaving out of account material considerations and so forth. That, I recognise, can be a difficult issue in EU procurement law cases. Nonetheless, the challenging parties then proceeded to lay before the contracting authority all of these new allegations and complaints which they were making about the ability of the successful bidders to comply with the selection criteria. This process occurred in mid-litigation, and the defendant in the proceedings, the contracting authority, then conveyed a further and, quote, final, unquote, decision to the effect that it was affirming the impugned contract award decision. The litigation then continued, but with this broadened scope and broadened framework, and indeed a challenge also, which was added at that stage to this further and final decision. Interestingly, one of the issues which then arose was that when this further decision was challenged as part of the same litigation, the applicant or the claimant sought to argue that the process which I have just described fell within the ambit of European Union procurement law, and the contracting authority resisted that contention. Once again, the issue was of an unprecedented nature, and the court's ruling was that EU procurement law governed all aspects of the procurement and contract award process. That, the court reasoned, flowed from the general aims and objectives and principles of the EU legislation. The court further drew attention to what in UK law is Regulation 26 of the 2006 regulations, which empowers the contracting authority to require any bidder to provide supplementary information, that is information which adds to information previously provided in the bid that has been submitted. The court's finding on this discrete issue was that this power was in effect being exercised by the contracting authority. One waits with genuine interest to see whether this point is ever tested at an appellate level or indeed within the ambit of the Court of Justice itself. The directive does not purport to regulate exhaustively public contract award procedures in individual member states, giving rise to this mix of dominant European Union law and domestic law. This serves to reinforce a related proposition. Once we enter the territory of litigation, European Union law encroaches only partly on the practices and procedures of the courts of member states charged with the responsibility of determining whether, in any given procurement exercise, there has been an infringement of the directives or any enforceable obligation under European Union law. One obvious and important point of reference here is Article 4.3 of the TEU, which obliges the court, along with all the other organs and authorities of the member state, to give full effect to the provisions of the directives and to the general principles of European Union law. However, it may be said that this relates essentially to the outcome of the proceedings rather than how they are managed and handled on a day-to-day or week-to-week basis from the beginning of the litigation to its conclusion. One might speak of a working rule or a general assumption that in the UK legal system, the triangle, which is composed of rules of court, which are formal, of course, made under primary legislation, secondly, judicial case management, and thirdly, what is common to all of our legal systems, namely the overriding objective, not perhaps framed in that way, I understand, in the Republic of Ireland, but a value or standard which imbues rules of court, is harmonious with European Union law. If it isn't, one of the parties will hopefully raise the red flag and formulate an argument accordingly. This places the focus very much on the national judge and serves as a reminder of a fundamentally important reflection, and that is that given the nature of the European legal order, the national judge is the first judge of the European Union. There can be other layers, as we are all aware, but this is where European Union law is played out on a day-to-day basis. Thus, it has been said in a European Parliament resolution, which encapsulates this very clearly, community law remains a dead letter if it is not properly applied in the Member States, including by national judges, who are the keystone of the European Union judicial system, and to play a central and indispensable role in the establishment of a single European order. One relates this immediately, of course, to Article 4.3 of the TEU and the early case law of the European Court of Justice, Van Gendenloos Costa, and all of those early landmark decisions, which are now approaching their 50th anniversary, as we are aware. So the judicial duty in its contemporary incarnation embodies a series of elements. The national court must apply EU law of its own motion in a case where it is to be applied, but the parties are not, for whatever reason, invoking it or arguing it. It must provide effective protection for individuals under EU law. It must interpret relevant national laws in conformity with EU law and must apply provisions which have direct effect, according these primacy over conflicting principles or provisions of national law. Furthermore, references to the Court of Justice for preliminary rulings must be made in appropriate cases. Thus, the national courts lie at the heart of the effective enforcement of European Union law, one dimension of which is dynamic cooperation with the Court of Justice. As it is sometimes emphasised in some of the newly acceded member states, this requires judges in appropriate cases to make findings against the government which has appointed them. That's one of the more difficult messages which one tries to convey in some of these countries which are struggling with the impact of European Union law. I found a very nice quotation, something written by Niall Fennelly of the Irish Supreme Court, who was formerly a judge of the European Court of Justice. And he said that European Union law has effected a revolutionary transformation of the constitutional role of the national court, an especially pertinent observation in a country which has a written constitution, unlike the United Kingdom. Now, this gives rise to another feature of the European legal order which I wish to highlight, and this is expressed as the principle of national procedural autonomy. It's another principle which can be identified in the early jurisprudence of the Court of Justice. It is frequently said by the Court that the national detailed procedural rules which govern actions, which in every case are actions designed to safeguard and protect the rights which individuals derive from community law, are perfectly acceptable provided that they are not less favourable than those governing similar domestic actions. And secondly, they must not render virtually impossible or excessively difficult the exercise of rights conferred by community law on community citizens. One can derive from this two further principles. First of all, the principle of equivalence of treatment of national and EU law claims, and secondly, the principle of effectiveness. That's a convenient shorthand for the general formulation. The Court of Justice has held that whether the relevant national procedural rule infringes the principle of effectiveness, it must be measured by reference to the role of that provision in the procedure, its progress and its special features, viewed as a whole before the various national judicial instances. I turn then to share some observations and reflections with you on the amended Remedies directive. Having highlighted the principle of national procedural autonomy, one finds within the sphere of public procurement a directive regulating what is loosely and generally called remedies, which properly analysed dilutes the principle which I have mentioned. The initial incursion by the European Union into this discrete field was effected by Council directives in 1989 and in 1992. The initial directive in 1989 stated that these measures were designed to coordinate the laws, regulations and administrative provisions of member states relating to the application of review procedures, that is, procedures reviewing the award of public supply and public works contracts. We now, of course, have the amended Remedies Directive adopted in 2007. As a general comment, I find reflection on the recitals in the amended Remedies Directive and the background to it very instructive where difficult questions arise, and in particular, frequent reminder of what the overarching aim of it was, namely to improve the efficacy of the procedures of member states for review and challenge, and also its express aim of fortifying the principles of transparency and non-discrimination, a very good example of general principles of European Union law emerging into the light of day in express and unambiguous terms. Two of the principal novelties, which are inextricably linked with the management of litigation, were the introduction of the standstill period and the automatic suspension of contract award itself. These were expressed to be prerequisites for effective review. The primacy given to the principle of legal certainty and the desirability of minimal delay in the economic arena are reflected in what all practitioners and courts would consider to be the stringent time limits which are imposed for the initiation of proceedings. Once again, the recitals in the directive draw attention to this. The frequency with which the principle of legal certainty features in the various measures of EU procurement law and remedies procedures is noteworthy. It is invoked expressly in the recitals and indeed in the provisions of the directives themselves. Most recently, we have had the introduction of a newly formulated time limit. In short, under both regimes, proceedings must be commenced within 30 days, beginning with what? Well, the touchstone is the date when the economic operator first knew or ought to have known that grounds for starting the proceedings had arisen. This is not a novel formula. It's one that is familiar to most practitioners of the law in various spheres. Equally, the dispensing power conferred on the court, namely that it may extend time where it considers that there is good reason for doing so, is something fairly familiar to all. That power to extend is subject to a backstop of 3 months. So 30 days can become a maximum period of 3 months, but nothing more. The background to these new provisions was found, of course, in the landmark decision of the Court of Justice in the case of Uniplex. In that decision, the court attempted to balance the principles of legal certainty and expedition on the one hand and the requirement of an effective remedy on the other. It appears unmistakable following this recent legislative change that the underlying philosophy is that the time limits regime should be a rigorous one. The proposition that the date of knowledge will, in the generality of cases, be the date of receipt of the contracting authority's written reasoned decision for eliminating the disappointed bidder from the competition seems uncontroversial and is a useful working rule for all concerned. My own view is that if it is viewed through the lens of a general rule, then there will be scope for identifying the unusual or complex or unforeseeable case, given that, as in every area of legal practice, every case will be unavoidably fact-sensitive. It's appropriate to reflect also on the requirement enshrined in the 1889 directive as it was amended, and that is that the contract award decision be accompanied by a summary of the reasons for the decision. In the recent jurisprudence throughout the United Kingdom, one can detect a degree of lack of sympathy for claimants who are tardy. One case, CETA, the Greater Manchester Association, gave rise to the court holding that, contrary to the argument on behalf of the claimant, knowledge does not denote knowledge sufficient to indicate a real likelihood of success in the proceedings in question. One of the observations which the court made was that this unsuccessful argument confuses the detailed facts which might be deployed in support of the claim with the essential facts sufficient to constitute a cause of action. One way of putting it. I draw attention in passing and leave you to consider the judgment of Lady Justice Arden, which was a dissenting judgment, which did not favour the test espoused by the majority, and which rather advocated a test that was faithful to the language employed by the Court of Justice. There may be some force in that when one considers that the majority judgments made reference to other provisions of domestic law concerning time limits, for example, latent damage. One might well predict confidently that still further quantities of judicial ink on this very important issue of time limit and date of knowledge will be spilled periodically, whether in the domestic courts or in the Court of Justice. We had a recent illustration of the date of knowledge debate in Northern Ireland, where the claimant argued that the date of knowledge should be measured from the date when the contracting authority, in fulfilment of a commitment expressed by email, had provided some further information over and above that enshrined in the decision letter itself. The letter, for good or bad, said, and there's something else coming, and we'll have it with you within 7 days. If that period of 7 days were reckonable, the claim would have been within the statutory 30-day time limit. The court ultimately rejected this argument, inter alia on the ground that the further information, which did in fact materialise, added nothing to the claimant's existing fund of information on the reasons for the decision, which was disclosed in the decision letter, and there was no attack on the adequacy of the reasons contained in that initial notice. In short, the claimant was waiting at its own risk in circumstances where it was sufficiently armed to bring proceedings, if so advised. The court was also unsympathetic to the argument that the measurement of time should be slightly relaxed in circumstances where the weekend was upon the claimant. The letter arrived sometime on the Friday. It was opened sometime on Friday afternoon. The business was locking up and everyone was going home. They took a quick glance at it. They realised they'd been unsuccessful and they decided to put off any further consideration until Monday morning. Again, if my recollection is correct, if those 2 days were reckonable, then the claim would have been in time. The court reasoned inter alia that the new European Union legislation, as transposed in domestic law, says nothing about that, in circumstances where it could very easily have prescribed consideration of that kind of issue. While this, of course, gives rise to the dispensing power of the court was unsympathetic to extending time, even though an extension of only 3 days was required in the particular case. A similar approach is found in other recent English decisions. The case of CETA I mentioned is a case of Merrimack UK Limited. And there is also a distinction which is emerging in some of the English decisions, and that, if I have understood it correctly, is that it is now possible in England and Wales for the defendant to apply for summary judgment. Now, for centuries, only the plaintiff could make an application of that kind. That's an application to the court for the grant of judgment at an early stage of the proceedings on the ground that there's no conceivable defence to it. In England and Wales, the procedure that has been introduced is that the defendant can bring a similar application on the ground that there is no conceivable prospect of the plaintiff succeeding. I'm not sure how that differs greatly from the pre-existing power which was contained in rules of court and also belonged to the inherent jurisdiction of both the English High Court and the Northern Irish High Court, which allowed an application to the court seeking an order, striking out a claim on the ground that it discloses no reasonable cause of action, with certain other provisions attached to that. It may be that the answer to my question is full evidence can be adduced in the summary judgment procedure, whereas under the other striking out procedure, the court must take the pleadings at their zenith and doesn't consider any evidence at all. I draw attention to a particular error which occurred in the case of Turning Point, the Norfolk County Council. In that decision, the bidder submitted a tender which was accompanied by a note setting out a number of questions about the competition itself. For that reason alone, the bid was rejected and litigation ensued. Proceedings were issued within 16 days of the letter which rejected the bid, fairly expeditious. However, the court held that the date of the claimant's knowledge had crystallised some 2 months previously. At that stage, the claimant had received answers to certain questions which had been raised, which, as you know, is a facility which can be invoked during the procurement process itself. And the court reasoned that at that earlier stage, the claimant must have had knowledge of the basic facts which clearly indicated the alleged infringement of the directive. The court also refused to exercise its dispensing power to extend time, reasoning that the legislation prescribes 30 days alone and not 30 days plus some reasonable, proportionate and short period, which brings me back to the point I made a very short time ago. The court, of course, did draw attention to certain hypothetical possibilities. There may be good reason to extend time, it was said, where, for example, an important member of the tendering team was unwell or uncontactable overseas for a short time, or, as the court pointed out, or detained. Detained for what? One answers. Now, what this means in very simple terms is that where part of the claimant's attack before the court is directed to the structure of the competition and not the outcome, the clock ticks from a much earlier stage. And that was one of the shortcomings which the court recently found in Northern Ireland in the case of Lowry and Wilson. I turn very briefly to one of my favourite themes, and that is that while everything proceeds with breakneck speed in the interests of legal certainty and in compliance with draconian time limits, there is no time for discussion, negotiation or compromise. The parties' energies, their resources, and their attention are all focused exclusively on the litigation. That is an enormous pity. I'll come in a moment just to suggest one or two ways of circumventing that, but it is worth noting that in Council Directive 1992, number 13, a conciliation procedure was introduced in this realm. However, it was optional, no one invoked it, conciliators weren't readily available, and ultimately it was recognised in the new legislation that it simply wasn't functioning properly. However, it has no substitute, and it therefore falls exclusively within the procedural rules and systems of national member states to devise their own mechanisms for consensual resolution of disputes of this kind. There may be willingness on the part of both parties to do so, and the court will in appropriate cases encourage it and will give them time and will allow the litigation to settle down and slow and delay while the parties engage in some kind of process. But another related issue here, and indeed a problem, is that of education. And in our judgments in Northern Ireland, the court has had occasion to draw attention to, first of all, the very complex nature of the legal rules in this sphere, and secondly, the need for intensive investigation of public officials and frequent updating in an area in which there is much development. We reflect from time to time on the experience of our colleagues in the Republic of Ireland. On the occasion of my last inquiry, it emerged that settlement was the rule rather than the exception in litigation there. We may discover whether there has been any update in that. In brief, litigation experience in our jurisdiction has demonstrated the need for intensive and proactive but very practical case management on the part of the court. That itself, of course, gives rise to certain resource implications, and ultimately it's down to the individual judge. One has to decide how much time one can allocate and how much priority can one give, bearing in mind Article 4.3 of the Treaty of the European Union, but also all of the ingredients enshrined in the overriding objective, which require the court to adopt a panoramic perspective, which takes into account all of the cases in the system, all of the litigants who are waiting, and all of the cases that are moving forward at one speed or another. Applications for a so-called interim order usually represent the court's first involvement in challenges to procurement decisions. I draw attention just to one feature of the principles which are applied in that context, and that is the issue which concerns the contention that there is no need for the court to continue the automatic stay of the award because ultimately the claimant could be properly awarded or properly compensated by an award of compensation. This issue now arises in every case. In England and Wales, the courts have adopted a robust approach. Basically, the line taken has been that damages are assessable one way or another ultimately, and monetary compensation is what it's all about. And what is being compensated is a loss of opportunity or a loss of a chance to acquire the contract in question. In Northern Ireland, it has been said, and I quote from a slide that was brought to my attention, which encapsulates this particular concept beautifully as I move on to one discrete point. 5 cases were heard by the court over a period of 8 days. This is when we had the blizzard in June 2010, I think it was, or 2011. I can't remember. In 4 out of 5, the contracting authority was unsuccessful. In other words, the court maintained the automatic suspension of contract award, whereas in the 5th, the contracting authority succeeded. It's now possible to review what happened to those 5 cases. I leave to one side the case where the contracting authority was successful. In the second case, Easy Coach, the claimant ultimately secured a victory, which is inadequately described as resounding. In a case called Clinton, known to some of our audience, the claimant also succeeded, and very interestingly indeed, an appeal ensued to the Court of Appeal. It was dismissed with a very firm and robust dissenting judgment by one member of the court. In the third case, which proceeded in tandem with the one I've just mentioned, there was a negotiated outcome. And in the final case, there was no judicial outcome. There was rather a consensual arrangement to which I am not privy. I mention very briefly one aspect of the litigation, and that is documents. There is a simply wonderful triangle where documents are concerned, or discovery or disclosure, as the process is called. The claimant is positively desperate to get his hands on every single piece of paper relating to the process, and in particular the assessment of all the bids. The defendant, the contracting authority before the court, has a position which oscillates from one of ostensible cooperation to downright refusal to what is frequently a bastion of cowardly last resort or desperate neutrality. Discovery of documents gives rise invariably to sensitivities regarding successful bidders. So far, we've had no great difficulty in circumventing those. First of all, the court has been prepared to allow these third parties to be heard on the question of documents. And secondly, mechanisms are available to ensure that sensitivities such as the wonderful cloak, commercial confidentiality, are in fact reasonably respected and preserved. By way of concluding reflection, I consider that public procurement litigation is complex, challenging and dynamic. Viewed in purely financial terms, the litigation risk for the claimant will almost invariably be substantially greater than that for the defendant contracting authority throughout the entirety of the litigation. My final reflection concerns that of access to justice. One is invariably concerned that there is progressively unequal and unavailable access to the court in the current economic climate, and one is also concerned that Article 4.3 of the TEU may be receiving lip service rather than enthusiastic and properly resourced cooperation on the part of the member states concerned. I thank you very much indeed for your attention.